Chapter 10 is something a little more relatable to you when it talks a lot about getting a job and maintaining a job, getting your contract, teaching certificate, your rights, student rights, discrimination. It's just more practical stuff, and I think you'll enjoy it. It was a lot more fun to do this lecture than some of the others. It also is a little shorter, and you're going to help me carry some of it this time, but I think you'll enjoy it. Chapter 10. Well, this Chapter 10 on the legal perspective starts out with the image like the others, and they try and give away a little information this way. As you look at this, it's a court proceeding with a stenographer taking notes there and somebody deposing a witness. And unfortunately, maybe fortunately, but this is what our schools have come to be. In fact, I believe we are paralyzed in school from doing the right thing because of fear of litigation and what it costs and all the ramifications of it. So throughout this, as they try, as this chapter, these authors and myself try to prepare you for this, just know we will run from anything that looks like it could get a little sticky. And I think it, like I said, it absolutely paralyzes us as teachers, as administrators at school, because of that fear of being litigated against. So let's take off on it here. Let me beef this up a little so you can see it. Not quite that much. So what are the legal aspects of this? The newest thing here in the highlight is social media, and they do a nice job of talking about this, not only for you as teachers, but as students, including people losing their jobs, being sued. And the most horrifying thing, of course, is people losing their lives over things through social media. So where does this come from? Well, it starts here in the highlight that the U.S. Constitution, the Bill of Rights, that evolves from interpretation of the Constitution, because there's no mention of it in the Constitution whatsoever. It was really taken upon themselves, and there's a number of things. And if you're a statist, if you're into federalism, you love what's happening to education in the preceding years. But for the most part, it's not mentioned at all in that. So several additional sources of laws exist at federal, state, and local levels that come into here, that mostly addressing disputes. And this is what I say: we don't want to dispute. We will just give up. If there's a dispute, give up. That's what we do as teachers. We just disallow, paralyze kids, freeze things. So some laws are developed out of the legislative process. Okay, and these are called enabling laws. And let me take you back here as we look at these. Here are the different ones. Like here is enabling laws, and laws that make it possible for educators to do certain things. Okay, so and that also laws that impose restrictions or prohibitions. Another form is administrative law, and that's rules and regulations the executive branches of government create, and schools must follow them. And then case law is what comes from the court. Federal and state courts and lower courts, but case law, and I maintain that this case law has had more effect on schools and what we do than administrative law or enabling laws for the most part. It's case law that paralyzes us. I don't want to be sued. I don't want any trouble. I don't want any trouble. I don't want any trouble. Okay, and the last, this judicial interpretive process, and that's drawing conclusions about the intent and the wording of the Constitution. And boy, you talk about something that's loose and mushy, because this is a one that changes over time, that interpretation, because it can be interpreted one way now, and another judge comes along, has a different interpretation of it. Appears that has been violated. Okay, so let's talk about this legal provisions of this. So how does federalists get involved? Federalism. So the Constitution, I'm going to add this caveat, supposedly is the law of the nation, where we've trampled all over it in recent years, but let's go with that for today. When Congress develops a new statute, it must be in accordance with the Constitution. except for like health care, No Child Left Behind, those things. If there's absolutely no provisions at all, they still impose those things. The last administration imposed No Child Left Behind on us. They have no authority to do that, but they did. I'm not arguing whether it's good or bad. I'm just saying the Constitution really doesn't provide for it. But if you stretch and mold and pick at the Constitution, you can find some grounds for it, as they have done. Okay. When a state legislature develops a new law, it must be in accordance with the Constitution, United States Constitution, and the state's constitutions. So 3 of the amendments, and again, I'm going to say to you, this is a stretch. 3 of the amendments to the U.S. Constitution are particularly significant to governance of the education, both public and private. Interpretations by the courts of each of these amendments, 10th, 1st, and 14th, have had profound impacts on the role and purpose of schools, the opportunities of all students to have access to it, and the responsibility and the rights of teachers, students, and school administrators. So their point is this, that because of these amendments, this gives authority to the federal government to be involved in your classroom. So here I'm going to, it's the 10th and the 1st and the 14th here, and I am going to ask you to bring those in here. Does not mention education, like I said. So you bring a note about this, and this will be our number 1. Right here, those 3 things right there. And the first is, Congress shall make no law representing an establishment of religion or prohibiting. And that one often is overlooked, not spoken, left out. Make no law respecting an establishment of religion or prohibiting that. And where that comes from, we don't really tell you about this in history, but where that comes from is many people fled to this country for freedom of religion. And what were they escaping? What religion? Well, it was Christianity, but it was state religion. In England, as it is today, the government and the Christian church are interwound, and that's why so many of the first settlers here were Europeans. Now, I know the history books that you studied, it was about freedom of economics, that people came here to, steal and pillage and run crazy. But their history books, for the most part, always stated freedom of religion, even though we've scrubbed that out of a lot of the history books today. So this is why in the Constitution they felt so strongly about the state not establishing a state religion because of the bad experience they had in England. But they also knew how important religious faith was, so they added this, or prohibiting the free exercise of religion. And that's the one I think we've certainly, in schools, done all we can possibly do to keep from establishing, but we've trampled all over this one, prohibiting it. Or abridging of freedom of speech, or the press, or the right of people peacefully to assemble, and to petition the government for redress of grievances. And again, for the most part, the government does not like that if you want to petition the government. That's not looked at peacefully very well. So that's the first, and you'll bring that in. The 14th is, no state shall make and enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, and property without due process law. Well, that's not entirely true, because the unborn are deprived of life. Nobody speaks for them, and no matter how you feel about that law or that statute, if you're unborn, you have none of these. And why that's curious to me is because we have people in prison that gave birth and then immediately killed the child. They're sitting in prison. But had they impugned that child an hour earlier before birth, we would say it's your choice and go ahead and do that. So that's really confusing to me, especially in light of the 14th Amendment. And you can go wherever you want with that statement, but it's very peculiar to me. And this I clipped for you on the clip page for you to bring in. So let's do that right about here. And we're going to call this number 2. And it's 10.2 clip. Goes right there. Okay, and we got one more to look at here. Where did that one go? 10th, 1st, oh, and the 14th. I'll make no or enforce any law which abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty. Oh, that's the one I was ranting about, yes. Nor deny any person with its jurisdiction equal protection of the laws. And they're saying that's you and students have equal protection. You have the right to protect yourself. You have a right to hearing. You have a right to be heard and defend yourself in court legislatively. And why that's important is because there was a time that wasn't thought to be. So the application of that 14th to public education is considered in this chapter deals primarily with the Equal Protection Clause. Let me highlight that. Equal protection, that you and the students have equal protection. Just because you're in school doesn't mean you check that at the door. It goes on, nor shall any state deny or any person with its jurisdiction the equal protection of the laws. So I say if you're charged with something or being discharged, you have the right to a hearing in the court process. That's due process. Okay. So let's get into this bigger one. See what we got here. Their constitution settles disputes over constitution. So what about church and state? Yeah, this is the sticky one, and probably the one, I shouldn't say it's one of the ones that schools run from any semblance of this. And that evidence of that, of course, is how we have now scrubbed so many Christian things out of schools from the time when there was Bibles and Ten Commandments and even crosses and prayer in school are all gone, and it's hiding from the courts. So it acknowledges, these authors interestingly acknowledge this strong religious heritage. And it's so interesting that we're so into encouraging folks to hang on to their heritage, except this part is discouraged. But people coming new Americans to this country, even those that have been here, are encouraged to hang on to that heritage, but not this. For example, colonial times education was primarily a religious matter, and many of those who attended were destined for ministry. Okay, so it goes on. The court cases concerned with separation of church most frequently involved both First and 14th, meaning due process and freedom of speech and religion. The First Amendment is interpreted as being applicable to the state's 14th. State that requires a daily prayer to be read in classrooms throughout the state could be interpreted as depriving persons of liberty. So that's the approach. If you're forced to pray, we've deprived you of your liberty. Okay, and as the states establish a religion, or at least prohibiting the free exercise of, states are not permitted to make laws that abridge the privileges of citizens, and the right of the free practice of religion must be ensured. But for the most part, it's not. Lots of court cases now about the kids that can't wear religious symbols, can't wear religious things on their shirts, on their clothing, stuff like that. I shouldn't say religious, mostly Christian things, because that's who bring them. Court cases related to the separation of church and state can be classified in three categories. Those dealing with the use of public funds, that's a big one. What about the funds? And then those dealing with the practice of religion in public schools, which is more what you think of. And then those dealing with the rights of parents to provide private education of the children. So that encompasses the fights over separation of church and state in school. Who gets the money? Can money go to religious education, private schools? 2, can we have any religiosity in the public school? And 3, what is your right to provide a private Christian education or private religious education? And then tons and tons of cases about each of those. Okay, private schools today, religious debates over funding, prayer, and curriculum abound. Often first and fourth, use of public funds to support religious education, practice public schools and parents are this. So let's go on here. Public funds, recent year of which statistics have been compiled, the students who attend non-public schools, 39% were enrolled in Catholic. We've talked about this before. from 2009 is this data. Said 39% that are not in public schools are in Catholic schools. In states with relatively large enrollments in parochial schools, ongoing efforts have been made to obtain public financial assistance, one form or another, for non-public schools. Did you know that? Yeah, there is some public money that goes. Now, it tries to clarify this. These attempts have often been challenged in the courts. Present a sampling of these cases in the issues here to illustrate this. Well, here's one: the transportation of students, church schools. Case of the comes this in 47. Court held in this in using tax-raised funds to reimburse parents for bus fares expended to transport their children to schools in New Jersey. Let's see where this goes, and I can come back. And it was found that it did not violate the Establishment Clause. The majority of the members of the court viewed the New Jersey statute permitting free bus transportation to parochial school children just as public welfare, just as public do. It's like a public welfare they got to help get the children to and from schools. Since the Everson decision, the highest courts in several states, under provisions of their own constitutions, have struck down that authorizing expenditure of public funds, children at schools. Others have upheld such enactment. So it's by state. I will say to you, I went to a private school, I went to a Catholic school, and rode the public school bus to school nearly every single day I attended there. So these tables I did not clip for you because they're so massive, but this gives you here about private education, and you can follow this down if you're interested in this, about how we got to where we're at. You can see the dates clear back to here. This is the one we just spoke of, Everson case. Can we have tax money to get kids to school? Okay. This one we're going to study, this Lemon versus Kurtzman, provide direct aid to secular service to non-public schools, including teacher salaries in this. And this the court said no, unconstitutional. Okay. This one, Woolman versus Waltner in 77, provision of books, standardized testing, scoring, diagnostic service, therapeutic and remedial services, non-public pupils. Court ruled that providing such materials and services was constitutional, so public education could. And I will say to you, I went to school in the 70s. We had lots of textbooks. Almost all of our secular textbooks were from and were stamped with the public school stamp. And then this one, in that same court case, provision of instructional materials and field trips to non-public schools, they ruled this was unconstitutional, that part of the law. And here's one, Grand Rapids in 85, and here's another two of them the same. Instructional of non-public school students in supplementary education by the public school teachers, and they found that this did violate the Establishment Clause. So that was a change. This one here, Zobrist versus Catalina Foothill Schools, provision of a school district's interpreter for a deaf student attending a Catholic school. And of course, that was found that was permissible, that they could provide that. And then, how about this one? Is where it got sticky. 94, creationism, creation in support of public school districts for Hadistic Jews of West New York State, and violated the Establishment Clause there. And then in 97, school district provision of Title I teachers to serve disadvantaged students in religious schools. Court overturned a ban provided the districts assign teachers without regard to religious affiliation. In other words, you couldn't make them have to have your beliefs. You couldn't have that. You can do that. It doesn't talk about this in the text very well, but for example, where my kids went to school, they had to sign a proclamation that they were a born-again Christian. If you're not familiar with that term, it doesn't matter because it won't apply to you then. But the people involved in that school, every one of them without exception, knew what that term meant, and so they had to sign that. But they're saying here you could provide a Title I teacher to that school for the poor kids, but you could not apply that same thing from that. And then it's some other things about removing religious symbols from the classroom and stuff like that. And so that was that. And then this came, the Lemon test, and I believe this one is the one that's on the test. And on the test it asks, what are the questions that you ask from the Lemon test? And this was found in a case in 71 about the entanglement of this. And let me just read this to you. The case was dealt with an attempt by the Rhode Island legislature to provide 15% salary supplement to teachers who taught secular subjects in non-public schools. And the statute of Pennsylvania provided a reimbursement for the cost of teachers. And of course, the folks were thinking they were doing a nice thing here by simply just paying 15% of the salary if they were in that private school teaching secular subjects, and they thought they were fine on this. And of course, it made itself all the way to the highest court, and it concluded this cumulative impact of the entire relationship rising under the statute. Let me slide over here. And here is the 3 questions that come with that. And this is what you'd have to know in the test. At least, does the act have a secular purpose? And it better be yes. And 2, does the primary effect of the act either advance or inhibit religion? And 3, does the act excessively entangle? And of course, that is what we can argue about the rest of the day, is what does entangle say? But does it entangle government religion? Most subsequent cases dealing with these funds in non-public settings have referred to this test, that you would ask those 3 questions before you would entangle the 2. And then this is interesting. Let me bring you back here. Here's the Lemon test. Separational clause that you could do this, but infamous 3-fold Lemon test. Have a secular purpose, either advance or inhibit religion, or does it act excessively entangle government religion? Most case addresses have criteria. Now here, I want you to make a note, and this will be number 3. What about special situations here? And so I'll let you look at this, and this is what always complicates it, is special cases or special situations. So the U.S. Supreme Court seems to have wavered from a strict application of the Lemon test in 2 more cases. So here's the law of the land, the Lemon test, and then we waver from that a little bit on these cases. Okay. Severe children with disabilities in this village of Hasidic Jews in the form of religious favoritism violated the First Amendment. So there's a special school for kids with disabilities that were Jewish, and they wavered there whether a public school district could provide the interpreter for a student who was deaf, and so we have that one. So those 2, you mentioned those 2 things for special situations. Okay. So what is this child benefit theory? The use of public funds to provide secular services has led to a concept referred to as the child benefit theory. And they do pretty good here. Public funds for secular services. So the courts found, yes, you could use public funds because it would be a benefit to the child. And here's the things they could do is transportation. As I said, I rode the bus. Textbooks, the secular textbooks. No, we don't buy you Bibles. We don't buy, religious textbooks, but secular textbooks, reading and writing and arithmetic and writing, and science, we'll buy you textbooks for that. And this was a newest one that we will buy with public funds because it's best for children. Testing, diagnostic, therapeutic, and remedial things. So that's all. That's the child benefit test we give it. And the services must benefit student, not school or religion, and that you would know. And this, a lot of this, I was outright of this. No Child Left Behind allows for funding for private school students. Any money that would come down that also upheld limited use of Title I funds at private schools. Remember what it said, that it could be, but all the things came into play in the textbook where the couldn't apply the same litmus test to hiring them, couldn't have religious symbols in the room where the services were going to be provided. So that's what that theory is. And it's 2 I clipped, and so we're going to move this. This is 10.3, and I'm going to put that at the bottom here. And this is number 4 and 10.4 clip I want you to put here. And the reason I have you do these clips is that I want you to have that in your notes, not only today, but going forward. The textbook's going to go away, but hopefully with these digital notes, you'll be able to access them someday. Or if nothing else, you'll have them to study for the assessment, the quiz on this but I have you keep inserting these things into your notes so you have them and have them for to study. All right. And here's the thing about Title I teachers in schools seem to be providing increased flexibility and easing the tension created from this law. In 85, court struck down use of Title I's funds to pay public school teachers taught in the programs. But this ruling, the court decided that under specific safeguards, Title I teachers can be sent to serve disadvantaged and religious schools. Okay. And it's just based on that religious school could have a population that meets those. And I said I was a free or reduced lunch kid 40 years ago, 35 years ago, and so that's the way that plays out. All right, 10.3 we did. Okay, and then how about religious activities? And this is so interesting, this image here, because for the most part of us here in the plains, we're very used to this. It was almost automatic that there was be some kind of a blessing that you would ask for. And now, of course, for the most part, it's completely prohibited. And this is the thing that schools, rather than stand and fight, ran like little girls, rather than try and defend this right of students and coaches to pray. And I'm just going to say how we do it. We still pray over our kids every time they compete. But what we pray, number one, is they're safe, and we see the injuries, and our kids have been hurt, and you could tell as many stories as I could about severe injuries in these sports today. But the other thing that we pray is that they're godly in their interactions and the way they conduct themselves, and of course that we as parents can be godly too, because we can get a little out of hand too. So how about the religious activities in the public school? Talked about that. Religious activities. How about prayer in school? Well, boundaries of First Amendment in school. Many cases have dealt with a prayer in school, teaching of creationism and evolution, the rights of the public facilities. Each case contributed to a gradual process of clarification of what can be done and what should be done to ensure the separation of church and state. All right, prayer in school. A number of attempts have been and continue to be initiated by school districts to incorporate some form prayer into public school classroom activities. One such case began in Santa Fe, New Mexico, and Santa Fe High School in Texas. Adopted a series of policies that permitted prayer, initiated and led by students at all home athletic events. That's all they're saying. No adults, initiated and led by students. And everybody thought that was fine. That went on a while. But in 2000, Supreme Court ruled in the Santa Fe Independent School District versus Jane Doe that the clear intent of the district policy was in violation of the Establishment Clause. Okay? Clear intent, and I'm not sure how they know that. 6-3 majority. So let me ask you this. If the clear intent was this, then why is it a 6-3 vote? Why wasn't it 9-0? I don't get how they knew that if not everybody agreed that. But anyway, they said that can't happen. Nevertheless, ask us to pretend that we do not recognize what every Santa Fe student understands clearly, and that is the policy about prayer. There in the decision, court noted the policy likewise does not survive a facial challenge because it impermissibly imposes upon the student body a majority in the election of the issue of prayer. In other words, the district would be imposing a particular religious activity on the majority of all. Clear violation of the Establishment Clause. And that's what the basis was. And that was the end of student-led prayer and activities in 2000. Because prior to that, we ended school prayer in the 60s, and up to 2000, the students could lead prayer. But that was the end of it after that case in Texas. Further empowers the student body majority with the authority to subject students to a minority views of constitutional and proper messages. Okay, so that's what happened to that. Okay. And that's what majority religious was. If you allowed that, they said that was like saying this is the majority of this. And often who objects to this is not people from other religions. Rarely these cases, and this is why it is Jane Doe bringing this, because it's people of no faith who challenge this. And they have the right to do that. But that's what happened to prayer in school, and student-led prayer was not other religions, the absence of religion. And then they got into, this is the latest one, evolution versus intelligent design, which I still think is nobody's business but the schools, but the courts got involved, and the curriculum people got involved, and Common Core will be involved in this. They'll soon dictate this. But this debate is traced to the publication of Origin of Species by Charles Darwin in 1859. So that's what I want you to put here. This is number 5. And I'm going to put it right here. Number 5, Darwin. You put that whole thing here, this whole sentence here. The debate is traced to the publication of Origin of Species by Charles Darwin in 1859. That was the first anybody cared about this, or where it was hatched. Okay. In following years of careful observation and documentation of the characteristics of plants and animals, Darwin theorized, remember this is 1859, he's come up with this, theorized that today's animals and plants were a result of natural selection over thousands of years. In other words, evolution. In approximately 150 years since that publication, the scientific base for evolution has become well established. And I wholeheartedly disagree that, like most science, when they couldn't find their way, they created stuff. There is no solid evidence for this, but let's give old Darwin the benefit here. A record, more recently, analysis of the genetic history of plants and animals. Some religious perspectives and a large proportion of the population view evolution as an unproven theory. Doesn't matter. It's now law of the land in a lot of schools. A lot of states have adopted that's the law of the land, even though it's unproven. The critics have used various strategies to challenge its teaching or to require an alternative view based on religion be taught as well. And you see some hiding behind that, okay, we'll teach both. But many states are saying we're not going to teach both. We're only going to teach evolution. One of the most famous trials involved religion teacher occurred in Tennessee in 25, and it had to do with scopes, and they called it the Scopes Monkey Trial. And I'll let you read that part of it there. I clipped this one also in the cases that led to this, 10.3, and so we're going to put that right here. And number 6 is clip 10.3, or table 10.3. Should say table because there's 2 of them there, and you bring that in there, and I clipped 10.4 also, so let's put them both here. This is 10.4 also, and this is just a figure. No, I checked on this. Don't worry about table 10.3. Just do 10.4 here. Number 6 will be 10.4, figure 10.4. Okay. Talk about prayer, cases, where that came from. Okay. So the establishment clause is, are you establishing religion? And that's what here is like a separation clause. Is it, are you establishing this? And then evolution, scopes trial, and then 10.4 you're bringing in figure. And here's the cases for separation of church and state. Oh no, this is the one for desegregation. Let me see where we're at here. All right. I think 10.3. I think I'm going to clip 10.3 for you also, and ask you to bring that in there, table 10.3. Let me do that quick here. Hang on. There. Now you have that too in your notes, and let's put that here. Put that back in there, table 10.3. So table 10.3 and figure 10.4 right there. Okay. And here's one final statement that's very interesting, and I just highlight the whole thing if you allow me. Regardless of the past Supreme Court decisions, some topics, such as posting of the Ten Commandments in classrooms and Bible reading in public schools, continue to be challenged by legislatures, individuals, and various groups. One of the outcomes of these ongoing challenges is an accumulating series of judicial interpretations that can serve as guidelines about what can and cannot be done. The summary statements presented in Figure 10.4 outline the overall pattern of many judicial decisions related to religion in public schools. Okay. And this is the part that I'm saying is hard, is why the schools have now ran like little girls, because they don't want to get anywhere near this word here, court. Okay. They don't want anywhere near that. So to avoid that, we just run. So here's the next big bite. Segregation and now desegregation. It wasn't a topic not too long ago. Let me run over here quick and just show you where we're going. This whole thing on the legal aspects of education, and we're clear down to here now on separation or segregation and desegregation. We'll have this big bite on your teachers' rights, and then the social media, and then students' rights. But we're up here working our way through. All right, so what about this? Well, the troublesome problem in the U.S. society has been the history of legal and social separation of people based on their race. In other words, segregation. And we do a terrible job in this country teaching about history, but you knew that. That becomes a big focus in our history today, is the segregation. Up until the middle of the 20th century, the public school system in many states contributed to this problem through the operation of two separate sets of schools, one for Caucasian and one for African Americans. And again, if you paid attention in history, you know about this. Segregated schools were supported by the courts. So as bad and horrible as we think that people were, state laws and official actions made that. State and local government administrations. This kind of segregation based on legal and official actions is called de jure separation, de jure segregation. Will you say that out loud, please? A little bit louder. De jure segregation. Go ahead. There, good. Because I want you to be able to speak correctly and pronounce those correctly. So there, that's maybe a new term to you. But in 1954 is an interesting year. My dad graduated from high school in 1954. The courts and communities made an intensive effort to abolish racial segregation in public schools. The process of this was called desegregation. And I'm going to say to you, they went crazy trying to desegregate schools. A major instrument the courts have used to accomplish this is called integration. The busing of students achieved a balanced number of students in terms of race in each school within a school district. So the courts, and this wasn't a courts, this was government, this was powers to be, decided we're going to desegregate these schools ourselves. We're not asking anybody, we're going to do this. So what they did, and there's very little written here about busing, but it was a huge deal. We talked about this in another chapter. Made kids that did not choose to get on a bus and ride across town to a school of a different race and go to school there. Okay, and we want a racial balance. So again, it was even different. And one person in the family maybe gets go-ons over there, another one's back. But one of the things that they forgot was that birds of a feather still flock together, that kids choose their own friends and who they want to flock with. So what happened, of course, they spent billions of dollars doing this, only to find that racial tensions weren't eased at all. In fact, the tensions now were with families, and families were fleeing to get away from this because their kids now were they're living right next to the local neighborhood school, but instead they get on a bus and maybe ride as much as an hour or more across town to a school from a different race, both ways. And so it was never professed, but I'm telling you, it doesn't happen anymore, but it was huge failure, and nobody would say that or take responsibility, but it doesn't happen anymore. A second instrument has been a user of a magnet school, which are schools that emphasize particular curriculum areas, disciplines, and themes. The hope has been that these schools will attract a diverse set of students. Okay, the word is attract. And this it's very contradictive here. Hope was this, that they would attract. Okay, these efforts to integrate the schools have mixed success, and that is, putting it politely, mixed, because like I said, what they found is the racial tension heightened from doing that, and not letting people select, not letting people volunteer, say, get on the bus, that's where you're going. Okay, and now there is increasing concern over resegregation because they stopped the busing based on where people live. Segregation or resegregation caused by housing patterns, okay, and other non-legal factors is called de facto segregation. So not legal. Remember, we had de jure, and now we have de facto. And, okay, just go with me now. You know where this goes. What about housing patterns? What does that mean? Well, who tends to live in the low-income housing? And where do we come from? I mean, we had many governments built low-income housing. Who settles in those? Of course, the kids that are poor. And they tend to be somewhat disproportionately minority kids. Oh, we can't have them all in one school. We've got to segregate them or prevent resegregation here. And so what was really frustrating, what makes this hard, is you move to a certain neighborhood for the quality of the school and that type of thing, and then government comes along and says, oh, no, 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 get on the bus, go. And so there's some concern. And they kind of leave this alone here now, a resegregation. But if you choose to go a certain place, it may be for the wrong reason, that you're a racist or something like that. If you send your kids to a certain school, what I think this does is continues to fuel the exodus to private schools and to homeschooling, things like that. But we'll come back to that. Separate but equal is no longer equal. Okay, let me just say here, segregation, and then de jure, and then desegregation. Okay, and then integration, and then magnet schools, or to supposedly attract, and then there's increasing over resegregation, people segregating themselves again. And it's just by where you end up living. And I say what I think is interesting is so often the government, the same government that doesn't like this, created low-income housing that attract people from low incomes. Let's spread those out, and let's not create entire communities that way. Anytime the government gets involved, these are unintended consequences. Okay. So what about this separate but equal? And this is what I'm going to ask you here. What are we on about? Number 7 here. You're going to get to put something here for each of those. 1, 2, 3, 4, 5. And I'll give you a little bit. You come back and put a note, put an explanation for each of those 5. And let me just pick a few things for you. 54, many states had laws either requiring or permitting racial segregation. De jure segregation. 54, lower courts upheld the doctrine separate but equal. But as announced, the Supreme Court in Plessy-Ferguson in this court upheld Louisiana law that required railway companies to provide separate things. And so that's what that was. The courts said it was okay to provide a train to take poor kids or kids to a segregated school. And then the failure, here's the next one, failure of the separate but equal doctrine. This separate but equal doctrine appeared to be the rule in 54 when the Supreme Court repudiated it in Brown versus Board of Education. And I would want to say to you, this is what you want to put in there, is Brown versus Board of Education of Topeka. Probably the most famous case in school law was Brown versus the Board of Education in 54. And the court said that the separate but equal doctrine has no place in education. So after the de jure segregation, the same courts come along and said, no, can't do it. So in 55, the court took more steps and stuff, but that you could no longer, and here's what it is. You could separate, even though both schools were wonderful, it wasn't equal if they were separated. And so now the little brown girl could go to the neighborhood school, and that was the essence of it. and I'll give you a chance to look at that later, but the essence of Brown versus Board of Education was the little girl was going by a neighborhood school that was a very good school, really close to her home, because she needed to go down the road a couple miles to the black school. And her parents, and of course, like any court case, by the time it got to Supreme Court and was ruled, she was out of school, or near the end of school, so it didn't really help her, but it had these lasting things of it. And this case here is the court case that led to desegregation and integration into schools. Okay. And then release from court orders, we're up to here. And you'll have something about here as years of court decisions and school district efforts related to unfolded. A new question was raised. What conditions must be in place for a school district to be released from federal court supervision? Because you're put on supervision if you weren't, meeting the requirements here. And so there's some cases here, and you will read this here first. There's a first and a second that you'll want to talk about here, and a third. Okay. And then achieving integration in today's diverse society here. Present, more than 500 school districts have experienced some form of federal court oversight to address segregation. So in other words, they didn't feel like you're segregated enough. The court stepped in. And at the same time, instead of schools and communities becoming fully integrated, there is a clear trend towards resegregation. And I disagree that the schools are doing this, especially in urban areas. As well-intentioned as the efforts have been to erase de jure segregation, de facto segregation is increasing. There's also an increasing diversity in the number of other racial and ethnic groups in most communities. Schools continue to be challenged to ensure that all students have equal access to quality education. And I think that's honorable. I mean, that's what it should be. Let's not worry about segregation. Let's worry about access to good quality education. The current strategy for achieving this to the end is some form of race-conscious assignment of students. Strategies such as magnet schools, including consideration of diversity admissions. So what we do, we create these magnet schools, and then we set provision, or we give extra consideration to minority kids. Giving priority to siblings in school assignments are being tried, as well as intention of the efforts may be. Some people perceiving inequality such each strategy is being challenged in the courts. Because what we do, like we so many, is we create these and then we say, but by the way, we're going to give preference to minority or poor kids. And hence what we're going here is reverse discrimination on that. And of course, so that's challenged in the court. So you're telling me that my kid doesn't get to go because he's not the right background, he's not the right culture, he's not a minority kid, so therefore he doesn't get consideration on his own merits? That's what we've done. Okay. So there you have that one. So let's go these court cases here. De facto segregation, race-conscious assignment, contemporary strategies. We jump over that. So discrimination. Let me come back here. Oh, equal opportunities, and we're coming. Equal protection here. Okay. Equal protection clause of the 14th Amendment. I gotta make sure whenever I do this, make sure I'm recording. See the little thing that says recording? That's why I do that, so I make sure it's working. Equal Protection Clause of the 14th Amendment has been instrumental in shaping many court cases and federal statutes that are directed towards preventing discrimination in schools. A judgment of discrimination can be defined as determined that an individual or group of individuals, for example, African Americans, women, or people with disabilities, has been denied constitutional rights. That's discrimination. Common use. The term applies to various minorities or to individual members of minority who lack rights, typically according to that majority. Principle that discriminates violates the Equal Protection Clause was these: Title 6 and 7 of the Civil Rights Act of 64, Title 9 of Education of 72, and their civil rights. So they're here, and you get to come here and put in what these are. These three things. And so this is number 8. Number 8, 1, 2, 3. Okay, and then what is affirmative action? Oh, yeah. 64 Civil Rights Acts, numerous statutes, and court cases have encouraged steps designed to ensure that the underrepresented, that's, you familiar with this term, we've talked about that before, the underrepresented populations have the equal opportunity. These affirmative action initiatives have included such actions as formalizing and publicizing non-discriminatory hire processes and setting aside a certain number of slots in hiring of college admission programs. So again, in my thinking, it's reverse discrimination because we're going to give preference to minorities. Okay, and certainly admissions. So again, my kid may be discriminated against, may be not admitted because he's not the right race. Okay, and over time the concern has increased about the possibility of reverse discrimination in that very thing, that you are left out because of you're not the right race. Situation in which a majority or an individual member of a majority is not accorded equal rights because of different or preferential treatment provided to a minority individual group. This concern has resulted in a new set of court cases, thank goodness, each of which attempting to redress what is perceived as a new imbalance. A summary of the events policies are in 10.5. And again, what happened is, not only in admitted college, we're leaving out very highly qualified people because they weren't the right race or background. And what happened, we did the same thing in hiring of people into jobs and management and stuff. So you ended up with people that weren't as qualified and maybe weren't going to do near as good a job, but they fit the right protocol that you're looking for. And hence that was reverse discrimination. And really, from some places, really messed up some programs and things because of that. Goes on here, as mentioned, legal basis for affirmative action found in these titles. However, affirmative action procedures and methods have continued to clarify increasingly questions. Okay, so I think I will give you this one also. So we're going to say this is 10.5 under here. Number 9 is 10.5 figure. Paste that in there from the clip page. All right. Back. So let me give you this last part here. As of 2012, 6 states, won't surprise you, California, Michigan, Arizona, Nebraska, Oklahoma, Washington, has established bans against using racial and gender preference in hiring, contracting, and college admission. So that's very interesting. And that's to fight reverse discrimination. The U.S. Supreme Court has once again been called upon to define the boundaries of affirmative action. And I'm saying to you, states, please stand by for rulings that will affect you. I've said this before. Let me give you a story again. I was discriminated against for gender. I applied twice for positions in schools that their constant goal was gender balance. And so if there's a school that has a principal and 3 assistant principals, at least one has to be a woman. So if the woman resigns and they're looking for a new assistant principal there that where there's already 3 men, I can apply and be interviewed, but I'm not going to be hired. And everybody knew that. They couldn't. You don't say that out loud. That's not allowed to say out loud, but I knew that that was going to happen. And sure enough, in both instances, a woman was hired. Now, I'm sure they were highly qualified. I'm sure they were more qualified than I am, but it helped open my eyes that, hey, don't apply for jobs where it has to be a woman in there. So that I thought was reverse discrimination there. Checking this here. Let's go on to what about the students with disabilities? What about students with disabilities here? I'm going to jump back here because we've done quite a bit of this. The legal basis is grounded in the Civil Rights Act, saying that they have a civil right to be involved in school. Let me go on here. Section 504 is a federal statute. Do you know what that is? Encourage the education of individuals with disabilities by making grants to states of local education agencies for children 3 to 5 require the federal government to be responsive to the increasing ethnic. Do you know they've never funded special ed like was promised when it was passed? When 94-142 was passed. fund programs to provide education to all children with disabilities. So what is 504? Civil rights established in 1973 said if you get federal funds at all, if you take federal money for any part of your business or what you do, you're prohibited from discriminating against otherwise qualified individuals. Okay, and this is why we have 504 plans in our schools, because of course all schools take Fed money. And so if you have Fed money, you've got to accommodate people with disability. Okay, so note that Section 504 is a federal statute and related regulations, not a court decision. The most important themes in this are equal treatment. And this is what we do in schools. Equal treatment, appropriate education for people with disabilities. And of course that's a little mushy what exactly that means. Equal treatment as a civil rights context must be addressed. However, this does not necessarily mean the same treatment. For example, giving the same assessment procedure to students with disabilities and others may not be equal treatment. Educational judgments in relation to students with disabilities require a heightened standard. The measures must fit the students' circumstances and stuff. So I want you to make something here. What is 504? And this is going to be number 10. 504. And the focus, of course, is equal, not same, but you make a statement in there. And then a couple things here. This is going to be number 11. Number 11 is what does PL stand for, and what does 94 stand for, and what does 142 stand for. So that's number 11. And number 12 is 94, 142, education of all handicapped children. What's the name of this today? Okay, there's 11 and 12. Do that now. All right. And you know this, the IEP, if you studied this at all, the IEP formulated by general and special education students with the parents' approval. The law provided for substantial increase in funding. Subsequent years, however, the funding or authorizations had been lower than the original commitment. And as I say, when it was passed, like so many things the federal government did, they promised the states 100% funding. Never happened. And now it's way down to the, I think 15% or something. I don't know if you could find that specifically, but I know it's embarrassment for what was promised and what's delivered. And the two priorities for funding were a child who currently receives no education and a child who is not receiving all the services he needs or succeed. Okay. And then IDEA, what that means, increased quality and rigor was one part of that. And this is what part of that was, is to align IDEA and No Child Left Behind. Definition of what is highly qualified, to come to consensus. What does that mean as far as teachers? In response to intervention, okay, I want you to do this too. I'm not going to put a number here, but I want you to put a big bold this next to it, a FAPE, and it's an acronym that we use in the educational world, meaning a free, appropriate public education, a FAPE. It's on increased quality and rigor, okay, and then IDEA, and then response to intervention approach. There is a question on the test about that, so what I'm going to do is ask you to make a statement about this. Read this here, and number 13 is here, a statement about this. What is RTI? Response to intervention. Not what does it mean, but what are they saying there about it? How it affects you? Part 2, teachers' rights and responsibilities. And you have rights, but boy, let me tell you, you have responsibilities too. Not only to the kids, but your community and to me, the parents. Teachers have the same rights as other citizens, so find comfort in that no matter what happens, you have the same rights as everybody else as a teacher. However, as teachers, there are some limits. The 14th Amendment gives every citizen the right to due process. In other words, if anything happens, you have the right to, process of law, a lawyer, face your accusers, those things, both substantive and process. And I have that a little bit later here, and I want you to bring that in here. So that's going to be our number one here. Number one. No, we are on number 14. Number 14 is this here part about substantive due process and procedural due process. Both things here. List them both and tell what they are. List and tell. Okay, that's 14. Most court cases related to teachers evolve from either liberty or property interests. And there's a question on the test right there. So most court cases with teachers is liberty or property interests. So liberty interests are created in the Constitution itself, but property is found in forms of legal entitlements such as tenure and certification. Okay, and let's talk about what those are. Teachers also have the same responsibilities as other citizens. They must abide by federal, state, and local laws. Now, is that a no-brainer? You're caught on ground smoking marijuana and expect to keep your job, and somebody will defend you saying you should. So it's things like that. As professionals, they must also assume heavy responsibility for educating young people. And this is the debate. That's interesting how it's stated, because we now are in the process of debating whose responsibility is it, how much responsibility goes to the teacher. We discuss specific court cases briefly here to illustrate some of the issues that court decisions relate as aspects of teachers' rights. Summarize. This summary table is not intended to provide a complete understanding. So first of all, the conditions of employment. Let me show you what we're going to do here. As I'm going to ask you, and this was 14. This is 15. You're not going to like this one as well, but it's going to work. And that is, number 15 is you're going to have one, you're going to make a line, a comment or a line on each of these. 5, 6, 7, 8, 9, 10. And I'm going to, don't start now, I'm going to go through and just pick at some of these as we go through them, and you'll bring a little information back for each of these. Okay? Here we go on conditions of employment. Many conditions must be met. You'd be hired. This includes successful completion of a professional prep program. That's me. That's us. Okay? So you have to complete a program. University, there's all kinds of ways, but somebody, someplace has to say, yes, you have completed a program in preparing to be a teacher. And then you have to be credentialed or licensed by the state. Remember, to get a teaching certificate, your university doesn't do that. The state of South Dakota or whichever state you want licensed, because some of you will have license in more than one state, and it could be more than two, depending on your moving around or how close to a state line you teach in or live in or something like that. So those two things, and receive a contract from a hiring school district. Each of these instances, you have the rights established in law to statute of responsibility. So complete a prep program, get a credential from the state, and receive a contract from the hiring school. So that's the first thing, those three things for that one. Then, teacher certification, primary purpose of certification licensure requirements is to make sure that teachers in the public schools are qualified and competent. The question on the test asks exactly that. What's the idea of that? Certification laws usually require a satisfactory completion of prep program, citizenship, no criminal record, and we now check on that. We ask you to declare. You have to know this, and let me tell you why that is. When I first came to DSU 100 years ago, there was a student that had a felony indictment or a felony charge pending. And when it came through, he was student teaching, and they went to the school where he was student teaching and took him off in cuffs. And we went, oh, we can't have that. So now we ask you to declare, do you have anything pending? What previous crimes you've been convicted of and stuff like that. And the most common one I see, of course, is open container. So now I'll be driving around in the car on the weekends with beer in the car or something like that, where you get busted for that. But nonetheless, that's the whole idea of this. And increasing evidence of instructional effectiveness. And what they're meaning there is now we're asking for things like portfolios and stuff that you have some proof that you're competent. Obtaining a license will be responsibility of the state education department. The certifying agency may not arbitrarily refuse to issue a certificate. The courts have ruled that local boards of education may prescribe additional or higher qualifications or requirements, that set requirements are not irrelevant, irresponsible, or arbitrary. I don't know if I knew that a local board could require additional things. And I suppose what that is, it's our preference will be people with master's degree, or people that have foreign language, or people that have technology backgrounds. I'm sure they could have those kind of caveats in their hiring, and they would be legal because they would be relevant and wouldn't be unreasonable or arbitrary. And then a certificate of license is a privilege that enables a person to practice a profession. That's what you get out of it. And that's not a right. Teacher certification are a property interest that cannot be revoked without constitutional due process. So that does happen. We'll talk a little bit about later, that you can lose your license, but only through due process, and the due process that you would have to ask for. If you're fired, and fired doesn't take due process as much as somebody revoking your teaching certificate. And who can revoke it? Who can revoke that license? Okay, and I'm going to put that right here, and put that here, who. Make that part of it. Who can revoke that? What about this employment contract? Usually education and authority, statutory authority to employ teachers. Okay, who does? Who has the authority? The Board of Education at the local school. And again, there's a question on the test that says that. Who has the authority to employ teachers? And now you know. It's the board, and we talked about that in the last chapter. This authority includes the power to enter into contracts. That's what they have the authority to do, to enter into a contract with you. And once it's inked on both sides, it's a legal binding contract that's not easily broken. Some states, only specific members of the school board can sign the teacher contracts. I don't know anything about that. What statutes confer that? This cannot be delegated. Is usually the responsibility of the superintendent to screen and nominate. Okay, and in a big district, it's a lot more than that. And generally, there's a human resource department, and for the most part, in buildings, the person that screens and nominates is the principal or somebody in a building. The board meeting is official session. Yeah, it's officially done at the board. Then the school board, the superintendent would officially bring those nominations to the board, not the principal. The superintendent would bring those. So I guess the superintendent would nominate this, but not necessarily screen them. And then the group gives consensual. And for the most part, at the teacher level, it's usually unanimous consensus. The superintendent says, I nominate these people. I can't imagine a scenario where the board turns them down unless a board member has some personal knowledge, and hopefully that's ahead of that. But where it could get a little more interesting is when there is, for a leadership position, there may be a little more give and take on that. Other than that, I can't imagine that. And then it really falls on the teacher to make sure that you're legally qualified to enter that contract, meaning that you have those credentials and you don't have things pending and stuff. Now, of course, we're doing background checks and all that relate to the same thing. Here, say, for example, a teacher may not enter a legal contract without having a valid teaching certificate issued by the state. And let me say this here, and people get all nervous about this, but you can, if they haven't granted it yet. This is common, happened to me. I signed a contract and started teaching before I had this in my hand. And so what the board says and school policy normally is you can begin, but we're not going to issue your first check till we have this in our hand. And there's cases where there becomes a glitch in the system and it doesn't come through. You didn't have a class that went through or something like that. You want to make sure that doesn't happen. But if you've graduated and the university says graduated, that's the university then forwards that to the state, and that's coming. So my first check was never upheld, but I did not have the contract in my hand the day school started. So that's your responsibility. So teacher tenure, let's go to the next one, teacher tenure. Tenure is intended to qualify, our laws are intended to qualify security for teachers in their positions to prevent removal of capable teachers by conspicuous action or political motive. So it's very interesting because nobody else enjoys that for the most part. Very few other sectors enjoy that besides teachers. But nonetheless, you're blessed to have that protection, and for the most part, you shouldn't need it. But it's the whole idea was so you couldn't be removed by conspicuous, capricious things. However, currently in many states there are serious challenges to teachers having tenure. Many perceive public employees as having too many benefits, such as paid health insurance, participation in public funding retirements. It's also perception not being easy to terminate a poorly performing teacher, and that is the biggest one. Very hard to terminate somebody once they get tenure. In the last few years, these views have been reused in several states by Republican governors and legislators to change tenure and teacher evaluation laws. Okay. In general, tenured teachers enjoy two key rights: protection from dismissal except cause are provided in state statutes, and the right to prescribe procedures. Non-tenured teachers may also have due process rights if these are spelled out in state statutes. So there may be some if it's spelled out. If you're non-tenured, maybe before you're tenured. However, most districts, states non-tenured teachers may be non-renewed without any reason being given. If a non-tenured teacher is dismissed and distinguished from non-renewal before the expiration of the contract, the teacher is entitled to due process. So if they still may be enjoyed have this if it's before their contract is up. Well, it means they get fired. That's what that means. It doesn't mean that, if you wait till the contract's expired and you're just not renewed, that's different. But if you're walk to the door, you're under contract and you walk to the door before the contract's up, you then are entitled to due process. If you're a tenured teacher, even if you're not offered a renewed contract, you're entitled to due process. So that's why it's so hard to fire. Here's the case law here. A lot of things about that, but I'm just saying I'm not sure we deserve that protection, but nonetheless we have it. So here is, I'm going to clip this for you, and you're going to bring this in now right here. Let's put it at the bottom of this one here, and this is 10.6, and so this will be number 16. 10.6 figure. Okay. And now this is a little different. I'm going to ask you to do is when you have read this, these 1, 2, 3, 4, 5, 6, 7, 8, 9 points, I'm going to ask you to come back over here and sign your name that you have read and understand this. And so that'll be in the discussion at the bottom for you to do. And so you do that right now. And here I have read and understand. Okay, you spell understand right. And this is what you write here. And your name will show up there, your username, and so I'll know that it's you. And make sure you do this, and tells me you understand your rights and responsibilities. Okay? And right to bargain collectively. Are you familiar with that term? You are right here now. Okay. So rights to collective bargaining. Let me just back up here. This one, discrimination. Just leave that one blank, just because the discrimination part really is back a couple pages here about hiring, and it doesn't really talk about that much, other than this case said the employees as well as students are protected under Title IX, that you can't discriminate based on gender. And those things. So just leave that one and just let's move on to collective bargaining here. Okay, so are you familiar with that term? Is that new to you? Just in the past, teacher groups met informally with boards of education to discuss salaries and other teacher welfare provisions. That's an interesting term. Sometimes the superintendent was even the spokesman for such teacher groups. In more recent years, formal collective bargaining procedures have been established instead of a more informal group of teachers meeting in the superintendent. Formalized procedures have been established. Now, a bargaining unit, it's called. Know that term, such as a teachers union, and that's often who the bargaining unit is, the teachers union, meets with a representative of the district, such as an assistant superintendent of human resources, and now, of course, their lawyer. Through bargaining, an agreement is reached that applies to all teachers, and hence one of the things that's going to limit you dramatically is the goose got to have the gander, that it all has to be the same all the time. And this is what happened to tenure, too, is that it no longer was good or bad teachers, they're all the same. And so you're negotiating a package for everybody, the exact same raises based on your time there. We talked about different salary schedules, those types of things, ways to pay teachers. Well, this one is dealing with a salary schedule, and it's not for one, it's for all. The procedure must comply with National Board of Relations, collective agreement. A contract arrived by teacher union means that the salaries, working conditions, and other matters within the scope of that bargaining agreement can no longer be decided unilaterally by the school administration. Instead, the contract implies that teachers union and its members will participate in formulating school policies and programs under which they work. And I haven't seen that very often where that was in it, that they'll be involved in school policies. So here's the first, and you're moving right on here. You got one of what is the rights of this. And that means it can't, once that contract is established, it can't be changed. Okay. So now the first one is bargain collectively from its local board of education was this one in Illinois, and here was the union. 1938. Second total local union was this. Okay. And they won the right to bargain, so you'll have that. And then is it being challenged? Beginning in 11 of several states, including Ohio, Florida, Pennsylvania, and Arizona, the right of teachers to bargain collectively came under major attack. The most visible example unfolded in Wisconsin, where the governor, Walker, Republicans-controlled legislature, passed a law eliminating collective bargaining. The state rationale was a need to balance the budget. However, the collective bargaining agreements with other groups of public employees, such as police and fire, were not treated the same way. Ironically, in 1962 was the first state to pass collective bargaining. Okay, so you have that thing, and that's interesting. That there's, for the most part, it is alive and well, and what contention is also, again, that the very worst teachers get the same raise, the same benefits and stuff as the very best teachers, and hence one of the problems with public education today. But politically, you don't get to talk like that. I'm just saying to you, it's a problem today. It's collective bargaining because it treats everybody exactly the same, and as you know, you are not all the same, just as in any other profession, it's not all the same. All right. Now being challenged, so you have something with that. So you've got that. Let's go to this next one: academic freedom and freedom from elementary and secondary teachers, book banning and censorship. Those there. So what is academic freedom? It's freedom to control what one will teach and to teach the truth as one discovers it without fear of penalty. So in this day and age, this is a huge statement that's very squishy. Teach the truth as one discovers it. Okay. So academic freedom is a freedom to control what one will teach and to teach truth as one discovers it. So do you know what that means? And this is why this whole one is kind of squishy. Academic freedom is thus essentially a principle of pedagogy philosophy. It's been applied to a variety of professional activities. Philosophical positions, however, is not necessarily a legal right. Okay, especially for K-12 teachers. Federal judges have generally recognized certain academic protections in the college classroom. While exhibiting reluctance to do this for elementary and secondary teachers. So, if you and I are both doing the same thing, I may have some academic freedom protection, and you may not. If they don't like what we're doing, okay? And so that's what, so for the most part, you aren't as protected from this as a college professor. For example, a contracted history teacher was not renewed after he announced that he taught his class from a Marxist point of view. The court ordered that teacher be reinstated in light of the university's failure to advance convincing reasons related to the academic freedoms. In another case, the university instructor claimed that he denied tenure because he refused to change students' grade. He argued that rewarding a course grade was the instructor's right to academic freedom. Because the university had given several valid reasons for non-renewal, the court did not order reinstatement. So they're saying they had other reasons besides that. So those are some examples. You write a little thing of what academic freedom is. Although federal courts generally have not recognized this for elementary and secondary teachers, the most supportive ruling was made in 1980. A case involved a high school history teacher whose contract was not renewed when she used a simulation game to introduce her students to the characteristics of rural life during post-Civil War. She did some role-playing and stuff. So here's some things of this. And again, ultimately, you do not enjoy the same freedoms as a teacher, K-12 teacher, as I do. Down here in summary, the academic freedom of the elementary and secondary teacher is more limited than it is for higher ed. First Amendment protections of free speech is increasingly limited to teachers' actions outside the classroom. Before arguing an academic freedom for free speech in the classroom, a teacher must show that he or she did not defy legitimate state and curriculum directives, followed accepted professional norms. So the burden becomes on you here. What does that mean? Well, that just means if you're going to disagree with the curriculum or disagree with what the school's doing or disagree with the school board or superintendent, you better know what you're doing. You better have some grounds. And then we're going to book banning. And I'm just going to let you pick this out of here, but basically you can't decide not to use a book or to use a book that the board says that you can't. You need to read this part here. This censorship battleground has to do with limiting access to World Wide Web. Amen to that. What's going to happen to that? This will bite you more. This will come up to you. Social media. Many school districts and states are establishing policies that restrict access to particular types of websites and limited teacher and student uses of social media. New questions related to defining what is meant by responsible use. And who decides? Teachers, principals, school districts, or the state are now occupying governing bodies in the courts. Okay, so who should decide that? Okay, this is a piece on academic freedom. Limited academic freedoms, must professionally be responsible, cannot disregard school board's decision on a textbook, must have freedom to provide supplemental methods, freedom limited when effectiveness jeopardizes. Okay, so here's the other one, a FERPA. We're going to talk about maintain confidential student records in the school, and parents have the rights to view those. Teacher written comments must be shown to students and parents upon request. So you know that no matter where you write it, even if you write a note on your desk, yes, if you write a note about a student on your desk, they have the right if they ask for it. Peer-reviewed assignments under law, and you don't see this anymore. I grew up in a time and when I was teaching, even this was not unusual that you would grade each other's. It's still allowed, but you see less of this. Teachers might be found liable for negligence or malpractice, and we'll take a little delve into that. So what is these things? You're going to get to come here. Let's see where we're at here. We are on this 16. So this is 17. 1, 2, 3. Good here, and this is number 18. 1, 2, 3. Okay, and this is what you need to know about the FERPA and the family. First of all, I want you to put that acronym in there as FERPA, Family Education Rights. And here's what you need to know. In 70, Congress passed a Family Education and Privacy Rights, which is also called the Buckley Amendments. Put that in there also, FERPA and Buckley Amendments, because you're going to get hit with that sometime, and I want you to be familiar with that term, the Buckley Amendments. This statute addresses the maintenance of confidentiality of student records. This statute does not prohibit teachers, principals, and other education professionals from making student information available for educational purposes, as long as they take steps to maintain privacy. Even today, many school administrators teachers and most parents do not realize that parents now have the right to view their children's educational records. You have the right as a parent to view anything written about your child. Many teachers are not aware that their written comments, which they submit as part of a student record, must be shown at parents' request. Now, they have to request to see anything, and of course, for the most part, they don't know they have that right or don't know what to ask for or what, but they have that right. Or in response to a student request, if the student is 18 or older. Know that. A student can do it if they're of age, 18. Key points teachers should know that FERPA are represented in 10.7. Let me just jump over there and look at that. Okay. Let's clip that also, and let's make that number 19 here. And that is clip 10.7, because I think it's important that you have that also. So how about grading papers? Well, there was a court challenge to it, is why we're even talking about it. And it was under this thing of FERPA. The suit was funded by the Rutherford Institute. The Court of Appeals for the 10th Circuit Court agreed with Oklahoma Parent that students should not grade other students' work. And in this 2002 Supreme Court was unanimous in overturning the Circuit Court. It said that privacy law was directed at records kept in a filing cabinet in records room or on a permanent secure, not grades in the classroom paper. So it was allowed by the courts. Correcting in classrooms can be as much a part of the assignment as taking a test itself. Way to teach material again in new context. It was now to show students how to assist. So it was allowed. So that was a court case. And it went to the Supreme Court. So what about responsibilities and liabilities? The different things here. So here we're going to have a look at these, and this will be number 20. And 1, 2, 3, 4, 5 things here. So more than 55 million students enrolled in elementary secondary schools. It's almost inevitable that some will get injured or educational activities. Each year, some will occasionally lawsuits in which plaintiffs seek damages. Such suits are often brought against both the school district and their employees. Legal actions seeking monetary damages for injuries are referred to as actions in tort. Technically, a tort is a legal wrong. I think there's a question on the test about what a tort is. An act or the omission of the act, and that's the thing you have to know. It can be an act or not doing your job as the other act. All right, put that in there. That violates the private rights of the individual. Actions in tort are generally based on alleged negligence. The basis of tort liability or legal responsibility is negligence. Understanding the concept of negligence is essential. Legally, negligence is a failure to exercise or practice due care. Okay, so that's what you want here. No, we're not to negligence yet. Put negligence under this one. Okay. Negligence of teacher supervision of pupils is an important topic that includes supervision of the regular classroom, departure of the teacher from the classroom, supervision of the playground, and supervision of extracurricular activities. Liability, on the other hand, is responsible for negligence, responsible for the failure to use reasonable care and such things. So, liability and negligence. You want to describe tort, negligence, and liability. All under here. So here's the thing with that, folks. You have a responsibility, and the biggest one I've heard of is this, that you're not where you're supposed to be. If you're supposed to be in the classroom, you're in the classroom. And as a rule, it is a wonderful idea to never leave your class unattended. If there are students in the classroom, you need to be in there or have somebody else in there. That's when things happen, even the low-level stuff. My experience was that's when you step out of the room to do something, that's when the big bully says to the little guy, we get out of here, I'm going to kick you, you know what. And then you come back in the class, and the little bully says, the big bully's going to beat me up. And the big bully said, I never said that. and you have no grounds. You weren't there. That's when we decide to throw a pencil across the room that hurts somebody, or that's all kinds of things happen. So if you're supposed to be supervising buses or the gym or before or after school or lunch or recess, you need to be there, or this is where this comes into play. It's a responsibility of doing your job. So what about educational malpractice? Well, culpable neglect by a teacher is in the performance of his duties called educational malpractice. As you will see in the sample cases described next, the courts have addressed many things. So here is each of these. You read these of all these things here. Negligent teacher and the field trip negligence, and make a statement about each of those, and then a thing about insurance. School districts to have this. Cost of school districts liability insurance increase this. But here's what it is. Even if there's a mistake, somebody gets hurt, if you're doing your job and have your stuff in working order, for the most part you'll be covered. If you're negligent, insurance still doesn't help you. You may get some financial compensation, but you may lose your certificate over it. And so don't be scared. I'm just saying, do your job. Be where you're supposed to be. Be responsible for what you're responsible for. For the most part, I tell you, another crazy place is in the gym. If you're a gym person, my goodness sakes, kids should not be in there touching equipment, doing anything without you there. And sometimes they can still get hurt, but you're on a lot more solid ground if you're where you're supposed to be, instead of in your office or in the teacher's lounge or getting a cup of coffee or a Coke or something like that. That's when these things happen. That's when the weights fall on somebody. That's when somebody gets hit with a shot put. Another, probably the most dangerous place potentially, is the shop. If you're a shop person or there's kids in the shop. So just be where you're supposed to be. Okay. Ooh, next part, social media. The ever-increasing variety of forms and use of technology are sources of promising practice for teaching and learning. They also are potential sources of problems for teachers and students. First of all, email. One of the most ambiguous forms of technology is email. Ubiquitous. It has become the basic form of communication between administrators, teachers, and between teachers and other teachers. Teachers may use email to communicate with students, parents, and problems can arise when the send key is hit before the message is carefully composed, or by sending the email to all instead of applying to the original. These mistakes can create embarrassing moments, but some can have more serious consequences. Okay, let me tell you another thing that's happened. It happens more frequently, and it happened to me. I'm emailing back and forth with somebody on a topic, and suddenly I decide to add somebody else to bring them into the conversation, but I didn't intend for them to see everything that was before that without cleaning that up. That was a problem for me once, but nonetheless, I don't have to tell you. You know this can be a problem, how this can happen, all right? So one is an employer monitoring. You may wonder whether it's legal or school district to monitor the emails you may wonder if it's illegal for a district to monitor the emails of its teachers or a college where you're studying teacher ed. If you use the college or school district email, then the answer is yes. And you learn the hard way, learn the easy way. Don't use school email or school computers for your personal stuff. You can have a problem if inappropriate content is discovered in your emails or your computer. For example, ultra frequently, school officials are finding pornography on teachers at school computers. Yikes! But here's the other thing. Here's he said, she said, all kinds of things with this. So just know. I mean, all your emails are monitored. Of course, I don't care where it is now with the federal government's monitoring everybody. It's all being monitored. But if you're doing inappropriate things, and even if you're not, you just want some separation between you and the school because they have the right. And here's what will happen, too. You may go a long time and not have a problem, and all of a sudden there's some little problem with something, and they grab your computer and look back through everything that you've ever done or touched on it. And they can't. It's theirs, whether you're a student or the teacher. Well, how about social networking risks? Using cell phones to take and share photos, as well as extensive social networking through the Facebook and Twitter, are causing concern and serious problem. And again, you have to have been under a rock someplace not to be aware of this. Content that is of personal and sexual nature will become the basis for dismissal. And again, please tell me I don't have to tell you this. It always seems to me that people feel like it's not going to be them. They're not going to get caught. And they always do. And there's some, some very famous cases of people texting and emailing bizarre things around. Even the accidental discovery of inappropriate content can lead to your fired. So keep the tips in 10.8. And I am going to, of course, clip this for you also to bring in. And this is going to be here. Tell me what number we're on. We're on number 21. Is 10.8 clip. Okay. Again, you know about sexting and what that is, and for some reason we have this unbelievable desire of teachers to do sexting with students. Sent nude photos of themselves with lewd exhibition of the boys who received the photos was in a possession of child pornography, and that's what it is. And so here you get to this "Who is Right" feature on this, and so that will be number 22. Who is right? Discussion. Let me go find that here. Should students be prosecuted as sex offenders for sexting? And I'm going to come back here and put that in here. And you can't respond until you have read both of these scenarios. Yes and no, and then you respond. Okay. Misuse of social networking by students may be viewed as happening through the innocence of youth. Similar behaviors by teachers are inexcusable, and I would agree with that. And that's where I would say to you, don't walk, run. Do not get near this. For example, the number of incidents of teachers using technology with students in inappropriate and illegal ways is increasing. The recent case in Los Angeles Elementary School of a teacher taking bondage-style pictures of children in a case in point. The teacher had been teaching for more than 30 years. He is now charged with 23 committing lewd acts with children. Unfortunate part of the Los Angeles case, as well as many others, is that nothing was done when one of the more of the children reported the teacher behavior to other teachers. Adults have a legal responsibility not only to report, but to make sure that these misdeeds are investigated. And what about cheating in technology? Fortunately, several websites are available to use to teach. Let me just read this whole thing. Another increasing challenge for teachers is to determine when students are using technology to cheat. Instances of using the cell phone while taking a test to snap pictures of test items, having an outsider call in the correct answers for more common than teachers can't want to believe. Plagiarism on term paper is another problem. Unfortunately, several websites and services are available to check for this. Teachers must be vigilant in classroom and unfortunately suspicious of how students are using social media. So that is cheating, and you have a little something about that. Okay. Student rights and responsibilities. Students have this: the right to a public education, to alienate homeless children, a right to sue, their right to have a due process. What about suspension, expulsion, and free speech? And so we have all these to talk about. So let's get at it. And here, this will be number 23. Here's number 23. 1, 2, 3, 4, 5, 6, 7, 8, 9 dress codes for each of those. And this is number 24. 1, 2, 3, 4, 5, 6, 7, 8 of these. All right. What a response. The rights of students have changed since the 60s. Before 69, school authorities clearly had the final say as long as they decided what seemed reasonable. A key Supreme Court 69 changed the balance by concluding that students do not shed their constitutional rights of freedom of speech and expression at the school door. Going further on behalf of students, in 75, the court decided that the principle of due process applied. These decisions led to several successful student challenges to school policies and procedures. However, since the late 80s, court decisions have moved back towards increasing the authority of public school officials. Along the way, students' life has become more complex, not only because of such threats as increased use of drugs, presence of weapons and gangs, but also because the diverse multicultural and shifting political context has made it more difficult to determine what is and what is not appropriate. And I think social media has made this compound this times 10 more recently. To illustrate some of the issues that related to the students' rights, to look at specific court cases. Okay, here's that. Students' rights as citizens. Okay. First of all, series of court decisions. All children in the United States have been granted the opportunity for a public school education, and you are just all you have to write under students' rights is FAPE. Remember what that stands for? Put FAPE and put what it stands for. Okay. Students' right to an education. Children in the United States have a right to an education. The right is ensured by many states' constitutions. That's where the guarantee comes from, the state constitutions. It's further defined by court decisions and how it is interpreted to mean that each child has equal opportunity. So it also has the courts. It is not without certain prerequisites. Citizens alone does not guarantee a free education. Students that establish a public school system also generally, those are cases there. This is cases for students' rights, long. And it's been probably bantered more than anything else in the courts in education. Also establish how operating costs will be met. Real estate taxes, this one. Residence does not mean the student, parent, or guardian must pay real estate tax. It means that the student must live in the school district in which he or she wants to attend. Residence, then, in a prerequisite to the right to a FAPE within a specific school district. Okay. Alien and homeless children have a right to school. Okay, that the children of illegal aliens had a right to a free public education. Did you know that? Alien is a weird term, but if you're undocumented or still are entitled to a FAPE. And not everybody agrees, but this is what the Supreme Court ruled in 82. Although today some continue to question this right, the courts have been consistent, holding that Equal Protection Clause applies to all. In addition, the court considers impact society of future educate all students. Related problem, more than 500,000 homeless children in the United States. And again, I wonder where they're at, because access to public school usually requires residence, address, parent or guardian, as well as transportation. Okay, Congress addressed the growing problem in 87, and I'm not sure why Congress would do that, why the states wouldn't do that, or even the locals, but Congress. McKinney Homeless Assistance Act on the test, which requires that each state educational agency shall assure that each child of a homeless individual and each homeless youth have access to a FAPE. The law was amended in 1990 to require each school district to provide services to the homeless that are comparable to others. And then the students have a right to sue. I'm going to let you pick that one, and the students' rights to due process. I'm going to let you do that one. And in the due process, you have to know in local parente, there's a question on the test about in local parente. Can you say that for me? Because I love saying that word. In loco parentis, it means in place of the parent. Procedural due process in case of suspension and expulsion, you get to figure this one out. But what all it is, you're entitled to a hearing before you're expelled or suspended. You have the right to face your accuser. You can get a lawyer if you like, especially if you think you've been wronged. So what is that substantive due process of students' rights to free speech? Let's see where we're at here. Right here, free speech. Tinker versus Des Moines in its school. If you want to figure unwind that, the Tinker case is probably almost like Brown versus the board. According to designate, that decision does not concern aggression behavior. The decision did not make it clear whatever the age. In a more recent Supreme Court decision to have at least narrowed the breadth of Tinker, the course involved Matthew Frazier, a high school senior in a school outside Tacoma. In the spring of '83, Frazier was suspended from school for 2 days after he gave a short speech at a school assembly nominating a friend for a position in the student government. School officials argued that Frazier's speech contained sexual innuendos, provoked other students to engage in disruptive behavior, and unfavored the school setting. Held that the Frazier punishment violated his free speech rights and First Amendment. The court appeals the Ninth Circuit decision holding Frazier's speech was not disruptive under the standards of Tinker. However, the Supreme Court reversed the decision in majority opinion. In this, Berger wrote, the determination of a manner of speech classroom and assembly is this. So the bottom line for all of this is it cannot be disruptive for free speech. It cannot be disruptive. Students' rights and responsibilities in school. Let's go to students. Well, how about dress codes? Well, first let me give you this. The right to privilege of children to attend school also depends on their compliance with rules and regulations. And this is what makes it more squishy. You know why? How about a homeless kid? We just talked about the rules. You had to educate them. What if they don't behave? How about the kid that's not documented and they're out of compliance with the school? Can they be suspended? And here's one that really lifts this up. What about the kids that are on IEPs, considered to be disabled, and they don't comply? Can they be suspended? This is where this gets a little murky. To ensure day-to-day orderly operation of school, boards of education have the right to establish reasonable rules. And this has been challenged in courts, is what is reasonable. Controlling pupils and their conduct. Boards' actions have been challenged in numerous instances. However, challenges have concerned questions as dress codes and grooming, corporal punishment, rights of married students, abuse and neglect, publications, freedom of expressions, those. So first of all, dress codes. And this is a long one. I don't hear about this so much anymore, but that for a time back in the 60s and 70s, it was a huge deal with it, especially with the grooming, haircuts, beards, those things. All have relaxed now. Lower court cases appealing with the grooming have been decided in some instances in favor of the Board of Ed, in support of their rules and regulations, and in other instances in favor of the student. So it's not clear cut. Dress codes is one that's not clear cut. A general principle seems to be that the dress and grooming do not incite cause disruptive behavior. And so that's what you would use to make this determinant, or a safety problem. They're likely to support the student. Dress codes, once very much in vogue, are less evident today. And that's what I see. Schools are a lot more relaxed about how kids dress. Now, when I was teaching middle school, they couldn't have alcohol or any kind of drug thing on them. If they did, they had to either turn the shirt inside out, or we had old shirts they could put on. The thing that we didn't allow back then was crazy, that was disruptive, is that all of a sudden they would come with very fluorescent colored hair. And the principal in our building at that time felt that was very disruptive. So if they came with fluorescent hair, they stood in the bathroom in the office with a bottle of shampoo, and they shampooed it over and over until it was gone. And we had kids stand there an hour, just keep re-shampooing their shirts. But they did get their arms around it. Here I'm going to go on here. The Supreme Court has yet considered a so-called long hair case. Federal courts in every circuit have issued rulings in these cases. Half of them found regulations on their hair unconstitutional, and half upheld them. So length of hair was big. it says 300 cases. Different courts handed up to 300 cases about the length of hair, and you don't see anything about that anymore. Nobody even recognizes length of hair. But when I was in school, that was a huge deal. Schools all had very strict guidelines for length of hair, which are completely absent now. If there's a trend, it's the students have won most of the cases in grooming, dress codes and grooming. Okay, corporal punishment. I'm going to let you look at corporal punishment and read it. Sex discrimination. Has to deal with Title IX, so you bring that in. This is an interesting one you're maybe not familiar with, is marriage and pregnancy. I want you to read through that and make a statement about that. We talk about child abuse and neglect, and so you put something in there about that. Student publications, lots are written about this. People printing inappropriate things. It had to do with the school newspaper, which doesn't seem to have gone away. We don't see as much as there was when I was in school about printing things in the newspaper. And again, for one thing, it's not a source, I believe, it's not as big a source of information to students because they have so much social media. And so who cares what's in the school paper? They don't read it anyway. Students, in this case, in 1970, students were expelled for distributing a newspaper named Grass High, which the students produced at home, which criticized school officials and used vulgar language. So when that showed up, here's what they did. They criticized, and this is probably the most famous case in student publication. Students were expelled. Federal court in Illinois supported the board, but appeal court, 7th Circuit, reversed the decision. The school board was not able to validate student disruption. See, they said it didn't disrupt. The expelled students were entitled to collect damages. Here's the one from '88, Lancaster Hazelwood versus the here. How about rights of students with disabilities? Come here. And we've kind of hit this already, but they're really entitled because of 94-142, entitled to the same education. This here, I want to hit this one a little bit because this will jump up at you more, and that is students and locker searches. And the image is very interesting, and that is the drug dogs, and much maligned, much debate and challenges to having the dog mark the lockers. And if you're not familiar with that, we used to have that in school several times a year when I was teaching in the middle school, and the dogs were sensitive to smell of drugs. Specifically marijuana. Most courts have refused to subject public school searches to strict Fourth standards. In general, the Fourth Amendment protects individuals from search without warrant. Many lower courts, however, have decided in favor of a more lenient interpretation of that. The rationale that school authorities are obligated to maintain and discipline a sound educational environment, responsibility along with their local parente powers, gives them the right to conduct searches and seizure and contraband on reasonable suspicion without a warrant. First, however, school and have only a search for evidence that a student has violated the school rule. Must be a valid rule and law in place. But drugs, the courts have really refused to mess around with anything that has to do with this because they have the right to have an orderly place and a safe place. School authorities do not need a warrant to search a student locker or a student vehicle. Did you know that? Because they have the right. And we see a lot of students getting in trouble when they have stuff in their car in the parking lot. Okay. So a locker and vehicle. So just know this and tell your students this. Their expectation of privacy in school is about nothing. On their computer, anything like that. For search of students' person, however, courts have a lot much tighter, and that is on their person. And what the rule is, the closer to their body, the more privacy they're allowed. Where a reasonable suspicion exists, a school official actions will likely be upheld. Reasonable suspicion exists when one has information that a student is in possession of something harmful or dangerous. And again, there's a lot more leniency now that there's drug is so prevalent. Money, a list of rolling papers. The second consideration may be the search of a student's person is conducted. School officials are advised to have students remove contents from their clothing rather than having a teacher or administrator remove it. Okay. Thing on peer sexual harassment. You'll review that and write about it. What is this one? I'm going to clip students' rights to and give it to you. And so that's going to be a number 24. And that is 10.9. I mean, number 25 is clip 10.9 as goes here. All right. And then emerging challenges. There are likely new cases related to drugs, testing, search of weapons, assaults. Assaults is one too, is different. We're not quite sure what to do with it. Policies, administrative directives, court cases appropriate to this. All right. Chapter 10, legal system. And now here I give you bonus. The rest of this is just for you. It's not the test or on the lecture, but it will be a service to you in the future as a teacher and prospective teacher. No extra charge on this. And let me just flip through it quick. Just a synopsis of the due process. That's all about due process. Learners' rights and responsibilities. Again, tinker. Can't be disruptive. Can't be critical if not disruptive. Can't censor. Freedom of conscience for teachers. Here's search and seizure. 4 basic tests for search and seizures. Teacher certification. We did talk a little bit about that. About gaining employment. Teacher contracts. Tenure and continuing employment. 6 ways you could lose your job. And then teachers' rights. And we've reviewed some of that already. All right, civil rights, lifestyle issues. All right, child abuse, reporting child abuse. Okay. You get all that for free.